Our next speaker is Professor Barak Erez. She is the Stuart and Judy Colton Professor of Law, Chair of Law and Security at Tel Aviv University. She currently serves as the Director of the Sigla Center for Interdisciplinary Research of the Law and a member of the Council of Higher Education in Israel, a member of the American Law Institute, and a member of the International Academy of Comparative Law. Her main research and teaching areas are administrative and constitutional law. She is also taught as a visiting professor at various universities, including the University of Toronto, Columbia Law School, and Stanford Law School. She's the author and editor of several books and many articles in Israel, England, Canada, and the United States. Help me welcome her here. Thank you.
Hello, I'm as delighted and thankful to be here as all my predecessors. And I will be dealing with the same topic of transnational law, but from a somewhat different perspective, because whereas Lorraine's presentation was normative, my presentation is more empirical and descriptive, but I believe will eventually will carry some normative lessons as well. And I'm going to discuss with you a special case study that I prepared, especially for this conference, and for a very good reason, because this is the case study of the citations of, guess who, Chief Justice Aaron Barak by other courts. So we usually tend to discuss judicial discourse, conversations of judges coming from different countries with one another. Or we may have discussions about resistance to transnational law in contrast to those who are willing to engage in it. But I want to look into something more concrete, and that is who cites whom and when. I mean, because when we discuss citations, so there is an implied assumption of equality, that if people are willing to cite others, so they will cite everyone. They will cite Germany, they will cite Canada, they will cite Israel. We are getting closer to my case study. But my intuition, also as a comparative constitutional law professor, was that it's not like this at all, that the practice of comparative law, even when we have this practice, is very hegemonic, is non-egalitarian, and this is what I want to look at. And my case study is the case study of the citations of Justice Aaron Barak by others, because if there is a chance that small countries will get to be cited by others, so this is the ultimate case study, a renowned judge, known all over the world, a leading academic. So he should be the ultimate example of a judge coming from a small country that will get citations elsewhere. And this is indeed the case. And still, I want to share with you who cites him, when, for which purposes, and I think that this is something interesting also in the context of our conference, because this is a conference honoring Justice Barak, and when I was invited, I thought to myself, what can I tell him that he doesn't know? Well, he knows so much, but at least this I can tell him he doesn't know about these citations, so this is my small gift. But beyond this, I think that it is an interesting case study for everyone who is interested in comparative law, who really wants to understand what is this practice about, what really happens there when we look into the smaller details. If I want to put my presentation in context, so it is connected, I think, to a few streams of study or thought. I mean, on one hand, it corresponds with what I will call critical comparative law. I mean, engaging in comparative law, but in a more critical manner, and which will highlight, I would say, the hegemonic undertone of comparative law. The other stream of literature which is relevant here is the study of judicial behavior, because we know that in the US, for example, there are many studies that focus on who gets cited, who are the federal judges who get more citations. But these studies are based on the assumption that since all these judges belong to the same system and there is an assumption of equality between them, so those who get cited more probably have better professional reputation. But we cannot adopt the same methodology when we take it to the global sphere, because here there may be other reasons for people to cite certain judges which will not be attached to their personal reputation, but rather maybe the reputation of their countries. So this is, I would say that this case study is at the crossroads of all these different streams of literature. So what did I do? Well, I just researched websites of courts, and I looked mainly to the English-speaking countries for practical purposes. I admit, you know, we can always do better, but I researched Britain, Ireland, the US, India, Australia, New Zealand, Canada, the European courts, South Africa, and I must say the German Constitutional Court, I had a connection, I had an internet, I would say email correspondence with Marcus on this. And I must say that also anecdotally, if I found other examples, so I added them, and Justice Barak, for example, mentioned to me a case from the Czech Republic, and Igal was generous enough to share with me an example from Poland. But in general, I mean, the basis of the case study is a case study of English-speaking countries plus Germany. So, what did I find? Maybe you are already curious a bit at this stage. Well, maybe, I hope. So, I found 61 cases that cite Chief Justice Aaron Barak, but I think what is more, and this is huge, I think this is a very big number. I mean, indeed, we don't have other cases, but this is a big number, I think, for everyone who has some feeling about what happens with foreign citations. And you will see that I even have 18 citations in the US, which is really interesting, right, for people who know US jurisprudence, not necessarily only from the Supreme Court or other courts, but still from the US. But I think what is not less interesting is to see where and why and when, and not only the numbers by themselves, although the numbers are interesting by themselves. So I tried to analyze my findings from a few perspectives. One perspective would be to see the differences between different countries. I mean, where are the citations found? And here the findings are not that interesting, or they are interesting in the sense that we can find these citations everywhere. I mean, all the systems that I researched had significant citations coming from the writings of Justice Barak. I mean, I don't want to tire you with too many numbers, but 18 in the US, 8 in the United Kingdom, 12 in Canada, 7 in Australia, and more and more. I just don't want to tire you. But I think the more, and this I would say, these are interesting findings by themselves, because they, I would say, reflect the professional reputation of Chief Justice Barak. But I think what is more interesting is to look at the subject matter and more nuanced findings. And here I would like to, well, some of you, I think I was a bit soft last evening over dinner, so I cannot really play this game. But those of you with whom I shared my findings don't participate. But can any of you guess what would be the main area of law in which I found citations by Chief Justice Barak? I mean, I would pose this question to the students. Do you have any intuition? Israeli courts will be cited by other courts on which topics? Any guess? Okay, I will not play this game too much. I'll just say that national security. I mean, Israel is renowned for its national security jurisprudence, and I think no wonder, and it is very much connected to the previous panel. The most cited decision is obviously the torture case, which is like a moral example for a court structuring moral legal policy. So 11 citations coming from there. What would be the other topics? Bioethics. 2 citations coming from a renowned Holocaust trial, the Demanuk trial. And if I want to offer an initial analysis, I would say that I learned from these findings that courts are interested in citing other countries in context in which they perceive the other countries to be experts of. So I don't know what does it say about maybe the public perception of Israel, but Israel probably is understood to be an advanced country about national security, about bioethics, about Holocaust, and also human rights in one very interesting area, equality of homosexuals. The Danilovitz case, which is a very important case of Justice Aaron Barak, is cited outside of Israel on this issue. And if I want to generalize more, I would say that judges are looking for moral guidance about the new issues. I mean, they know enough about contract interpretation in their own system. They can deal with regular tort litigation using their own system. But when they are confronted with new moral dilemmas, this is where they need additional instruction or inspirations. And I think that this theme comes very clearly out of the numbers. By the way, as we know, and this may have some connection to Lorraine's presentation, judges can do many things with the citations or with the sources they find elsewhere. It was very interesting for me to see that in England, for example, a system that heavily used Barak's torture decision in a very renowned and important House of Lords decision also on the issue of torture, the A versus Secretary of State for the Home Department, the issue of use of evidence that was sent to British authorities by third countries suspected to use torture, and the question is whether British authorities can use this evidence. So it's so interesting to see that both the Court of Appeal and the House of Lords used Barak's decision to support their views. The only problem is that their views were in contradiction. The House of Lords reversed the Court of Appeal, but both courts, both instances found, I would say, important moral inspiration coming out of Barak's decision, which was, I would say, something very major, central to the formation of the judicial policy on this issue in Britain. Since, well, I have many findings, I'll have to be more choosy and go to the next, the other half of my findings. Another distinction that I would like to share with you is the distinction between citing cases and citing legal literature. Because, of course, Justice Barak is renowned not only for his decisions, but rather also for his academic writings. But not ordinary academic writings, but rather academic writings as a judge, because his most renowned books in the US were books that, as Yigal said in the morning, books about his theory of judging, his understanding of a judge in a democracy. So the question is, when other courts are looking for moral instruction and inspiration, where do they go? Do they go to the cases, or do they go to the literature? Or probably to both, but where and when? And here my findings, I think, are also to some extent interesting, in the sense that more than half of the citations are citations of the books and not of the cases, although they reflect the same judicial theory. And when other judges refer to the books, they say, we refer to the books of Chief Justice Barak. They don't say we refer to the books of Professor Aaron Barak. I mean, they want to look for his instruction as a judge, but they use the books. What is the explanation? I suppose very easy explanation that we can all share. I mean, this is accessible. This is in English. This is on the shelves of every library. I mean, Princeton University Press, such Yale University Press. This is easy. And we see that in India, for example, all the citations are from the books, not from the cases. And they say, we look for the judicial theory of Aaron Barak, but they find a guidance in the books. And I think that it also tells a lot about the practice of comparative law. For a comparative law to be influential, it has to be accessible. It has to be English. In English, it has to be easy to find. So if we want to understand something about the practice of comparative law, we should take into consideration these limitations, because I want to remind all those who sit in this room, I suppose most of you know that, English is not the formal language in Israel. I mean, the formal language of the legal system is Hebrew, and the decisions of the Israeli Supreme Court are written in Hebrew, which is almost like Chinese to most people in the world. So some of the most important ones are being translated. So, of course, we cannot be here neutral as well. Only translated cases have any chance to be cited and to influence. And for countries who want to take part of in the comparative game, this is not enough, but the first thing would be translate. And by the way, there are many, I would say, weird and strange ways of translation. I must share with you a personal story that it's not included in the paper, but just 2 days before I left to arrive here to Oklahoma, someone sent me a new court decision from the High Court of Delhi, because this decision of the High Court of Delhi included a citation of the Israeli Supreme Court on censorship of movies and citing Aaron Barak. So I said to myself, well, great, although this is beyond the time limit of my empirical case study, but still, you know, interesting. But what was not less interesting for me to see that as I was reading through the case, I saw that a judge in the High Court in Delhi said, well, we cite the Israeli Supreme Court as it was described by legal scholar Daphne Barak Erez in, by the way, a law review article published in California. So this is, I would say, a real story of legal globalization. I mean, you have to be accessible. I suppose that a law review article is more accessible to the court in Delhi because maybe it's on Lexis or Westlaw, and then through there it can get to what the court is really interested, and this is the inspiration coming from Justice Aaron Barak. So here we close the circle. So these are my main findings. I could, you know, go on and on. As I said, I think that there is some value, I hope, in this case study also because it celebrates the jurisprudence of Chief Justice Barak. But for me, and I want to go back to where I started, as a comparative constitutional lawyer, I think it is also important in a broader sense because it exposes the hidden biases of comparative law. It exposes issues of linguistic barriers, political, I would say, preferences, and I would say that taking into consideration all these barriers, I would say that Chief Justice Aaron Barak was cited against all odds. Thank you.